Right, so we are on property ownership, kind of went over um, what some of the things that you're going to be expected to know in this section. I'm sharing my screen now. This isn't everything. I'm gonna add them as we look at some questions and stuff. But when property ownership is all going to be definitions, it's going most of the stuff in property ownership is going to be definitions. So if you're good at definitions, you should do good in property ownership. Property ownership is 10% of the test, so 8 questions. And really what they're going to be trying to test you out of in property ownership is if you know the difference between what joint tenancy with the right to survivorship means when compared to tenancy in common. So know the differences between what joint tenancy and the right to survivorship is, and then know the difference in tenancy and common. So these are just some of the things. We're not here yet. So let's go to the manual, and I'm going to just go through the section again, starting from the top. And I'm going to tell you to as we go through this, I'm going to tell you what to write down if y'all taking notes. I'm gonna also put it on the sheet once we do it. So once we talk about it. So let me explain something too. Property ownership, the book says that that's the first thing you should study, right? But I don't agree with that. I think for the test, it's important for you to know how to create a relationship, what your fiduciary duties are. And once you understand that, then what are the documents that you use to get you into that agency relationship? And that's the way that I went over it. Plus, those are the two most important sections of the test. So um, let's look at the manual. And we already on it. We already kind of own where we need to be at. All right, so right here on that test, you're gonna probably get a freehold question. Now, what is a freehold estate? A freehold estate, and write this down, means you own it. You see own right here? Write that down. Let's zoom in. So right here. Yeah, that's real big. All right. So first off, I want to start off, like I said, last class, you can only do two things with real estate. You can either own it or you can lease it. The types of freehold estates or the types of ownership interests that you can have in real estate is three of them. One of them is fee simple absolute. So we're gonna need to know what that is. We need to know what fee simple defeasible is or fee simple conditional. On the test, they're gonna change it. They might say conditional or they might say, I don't know, limited or something like that. But defeasible is really what it's called. And then you got life estates. So those are the three ways you can own ownership. You can own it in fee simple absolute, fee simple defeasible, and in the life estate you can own through a life estate. And then the other side of that is leasing. So it's called a leasehold estate. So when you lease something, you have a leasehold estate or interest in that property. Now, how is the interest determined? It's determined through a lease. So what type of lease are there? You got a state for years, you got periodic, you got a state at will, you got a state of sufferance. So I always start with the easy one. A state of sufferance means that the landlord is suffering. It's like a squatter in the house. Um, they're not paying the rent. A state at will, the word that I key on in the state at will is the will part. And I always think to myself, like, who would I will something to? Like my kids, my parents, or someone, one of my heirs, or something like that. And typically, with that type of setup, the person can stay there as long as they want to, and they can stay there until either you give them a notice to vacate or they give you a notice to vacate. It's kind of similar almost to a month-to-month lease, really, but that's not what it is. You very rarely see a stay at will as a question on the test. I'd be very surprised if you saw that. What I'm saying is of the four, that's not one of them that, if you're struggling with it, that's not one of them that I would be really like overly like, you know, hard on myself if I didn't remember what it is. The next one, periodic estate, what that is a month-to-month lease. Periods, like month-to-month lease. Periodic estate is a month-to-month lease where if the person pays at the beginning of every month or however it was set up, they get it for another month and they have a leasehold estate for a month. And then the estate for years is a lease that has a definite end date and a definite beginning date and a definite end date, like a 1-year lease or a 2-year lease. That's what an estate for years is. All right. So those are, and what we need to do individually is create our own definitions for those. But if you get tested on anything on here, they're probably going to ask you a question about a life estate. They're probably going to ask you what fee simple absolute is. They're gonna if they ask anything about the leasehold stuff, I would definitely know what an estate for years is, and then a periodic lease is. Estate for sufferance, that's easy because when you see the sufferance, you know that the landlord is suffering. It's kind of like a squatter situation, so you should be able to easily go through that. Now, here are some of the things that and explanations of what the freehold estates are. All right, the fee simple estate is not limited by one's lifetime. All right. That fee simple absolute estate will pass on to their heirs. Absolute means the highest form of ownership interest. All right. Now let's talk about fee simple defeasible. It reverts to the previous owner per conditions. So in the last class, I used an example of a church selling a property and they didn't want certain uses to be done on the site of the church, like gambling, like liquor and alcohol and stuff like that. And so they could put a deed restriction in the actual deed and limit or put conditions on the use of the property. If you violate those conditions, it reverts back to that owner, obviously through some sort of litigation, but they would bring a suit and cite the conditions in the deed, and it's up to the court to figure it out. So you got to fee simple defeasible. It's close to absolute, but there may be one condition, there may be many conditions, but it has conditions, so it's not the highest form of ownership. Very close though. All right, and then we got life estate. It passes to another on the death of the named person. And the example I gave is that a mother or a kid, say for instance, you have a kid or somebody has a kid and they're grown and you're in your later years and your kid says, I want to make sure my mom or my parents have somewhere to live for the rest of their life. So they give you a life estate on a property. And upon the death, the person's death, when they die, the life estate reverts back to the person that gave that person a life estate. All right. Now, most of the time it's set up to make sure somebody has somewhere to live for the rest of their life. All right. Now, it may be multiple people that set up in a life estate, meaning that once that person moves on, there may be somebody else named in that life estate that it passes on to upon that person's death. That person is the remainder man, and that's on the next line. Do you need to know the definition of a remainder man? If they ask you it on a test and you get it right, that's gonna be sweet. If not, I'm not gonna say don't study it and don't know it, but if you can retain that, it's just good knowledge to know how a life estate is treated in general. And so again, once upon that person's death, it goes to the next person. That's the remainder man. It might be the father, assuming that both parents don't die on the same day. So you might say, okay, my mom passed away. My father is not going to be the remainder man. or my mom is going to be the remainder man if dad moved on first. So what it pretty much is it's a person that's in succession um, to receive the property if they're named as a life estate recipient. If there is no remainder man, it's going to just revert back to the owner, the previous owner right here, reversion to the previous owner to receive the estate back to that person. Then you got a conventional life estate. That's one just set up between you and an attorney, and you might have an attorney do the documents and stuff. It's just conventional like that. And then you got a legal life estate where the courts would set up the life estate. So, but I would not even worry about knowing that part of this. I don't think they're gonna go that deep in terms of testing y'all. So those are the freehold estates. So you may get a question. I might ask you a question like name the three freehold estates. You're gonna say fee simple absolute, fee simple defeasible, and life estate. And if I ask you what a remainder man is someone who received the property after the named party's life the main name party person moved on. They're the next recipient in line of a life estate. Or if I ask you what a life estate simply is, you would just say a life estate is when someone else has ownership of a property until the end of that person's life. And then if it is either going to go to a remainder man or it's going to revert back to the previous owner. All right. Any questions on freehold estates? I mean, it sounds real simple now, but when them questions come up on that test, even the practice questions, it seems like they don't be that simple. Um, I'm gonna keep moving. I don't see nobody saying anything in the chat, so I'm gonna keep moving. And here's the legal life estates, and this is all in that book, so y'all can get in there and look at some of this stuff too. All right, moving to leasehold estates. All right, and it's just that simple. It's like what we gonna try to do with these is try to create just short definitions to give us a hint into really what we're trying to look at. So these are a different type of leasehold estates. Remember, you can only own or lease a property. You're either gonna be owning it or you're gonna be leasing it. There ain't no other way you can hold a property. All right. So estate for years, this is a type of ownership, it's specific. Stated duration, know that it's a stated duration. That's the thing that differentiates this. All these little italic things are the ones that really differentiate these from the others. It's just got a stated duration per the lease, expires at the end of the term. All of them will have a term, should, except this one. But what that means is that it has a definite duration, a start date and an end date per lease, and it expires at the end of the term. It's over with. Now, typically, a person that was in an estate for years, if they don't leave the property, they turn into an estate for sufferance. Right? Once this thing expires, it's a tenancy against the landlord's will, and without an agreement, this agreement is terminated up here. So typically, when the person in an estate for years, they'll turn into a person in the state for sufferance if they don't leave. All right. Periodic lease is lease terms renews automatically upon the acceptance of rent, renews indefinitely if the landlord accepts the rent. That's a month-to-month lease. All right. So if in the question, if it sounds like a month-to-month lease, then the answer is a periodic estate. The way they use these questions on the test is they use the estate for years and mixes them up with the ownership types because like it says estates all in this stuff, and so they try to confuse you by mixing them up with this stuff down here. This is ownership right here, right? And then this is just how you are leasing it or how you are owning it up here. So that they in the questions you'll see some your leasehold estate as answers to the question, and that's how they try to trip you up. So you got to know the definitions in here on the test. That's how they try to trip you up, and on the PSI questions, that's how they try to trip you up. I'll point it out when it happens, but that's something that you want to pay attention to on the test. If you know the definitions, with this is one of the areas too of the test where you got to slow down and read the question and really know what they're asking you because they're definition questions. All right. And if you do that, then you got a higher chance of getting it right. So yeah, so periodic is the month to monthly. Estate at will is for an indefinite period. This person can stay there as long as it may be subject to rent payments. They could just be there. It could be a sweetheart deal with your kids or a family member. You just letting them live there. You're not charging them any rent, and it's cancelable only with a notice by the owner or the person that has the leasehold estate. So it's an indefinite period of time. It's not anything indefinite. It's no end date. It's no start date. However, and the only person that you would do that, that's why I say at will. Only person I'm gonna have do that is gonna be somebody that I know, and they're gonna be either related to me or a very close friend or something like that. And so that's just kind of how I associate it with the will part. It's gonna be somebody I know that I'm gonna allow to live there for however long they want to, or until I get sick of them or they want to leave. Right? And that sounds like a child, or somebody that's real close to you, like I said. So it's only accountable with a notice. And once you notify them, hey, vacate the property in 60 days or whatever it's going to be, they'll have to leave the property at that time. And then the state of sufferance, tenancy against the landlord's will and without an agreement. All right. That one's easy for the landlord to suffer, and this is a squatter, somebody like that. Now, the ownership, this is the key part because you probably will get about 4 questions about these different things right here. All right. So, tenancy and severalty. The way I remember this is when it says severalty, that sounds like it's a whole bunch of people or numerous people. But severalty actually means the opposite of what it sounds like. It means only one person. So, sole ownership of a freehold estate. Sole ownership of a freehold estate. Like if you went and bought a house and it was just you would have sole ownership of that freehold estate. All right. So when you hear freehold estate, think ownership. It passes to your heirs upon your death. All right. That's the type of ownership that you can have. So somebody buying a house, one of your buyers may say, and never say this to you, but if they did, I want a tenancy and severalty, and that means that they want to buy the house and own it themselves with nobody else on the deed, no co-owners. All right. Tenancy in common. This structure is typically done with business partners or brothers and sisters, somebody like that. All right. The key to this is that they're co-tenants and they individually own undivided interests. What that means is if us four that's in this group right now say we want to buy a house, every last one of us, we could all own it in different interests in terms of percentages, but we all have 100% right to use the house. Now it might be based on our interest, the interest that we have, but I could own it 25%. Kiana could say I want 35%. Maria can say, hey, give me 15%. And then whatever's left over, Tanisha can say, hey, I'll take that. We can own it in different percentages. That's what you got to remember. It don't have to be 25, 25, 25. All right. That's key to this type of ownership. Any ownership share possible. That's what I just explained. Right. The first thing we needed to understand is that it could be multiple people that own and have interest. Right. Undivided interest. That's the key. Like the undivided interest means that I have 100% right to whatever it is too. Now it may be, in other words, you can't exclude me from using something. So say for instance, we own a house and I only own 10% of the house or a share of the thing. You say, okay, since you only own 10%, you can't use the swimming pool. All right. I get to use everything too. Now I might only be able to use it one day of the month, but I'm gonna be able to use it, you know. Um, so the other part is any ownership share possible. That's what I mean. We can own it 25, 25, 25. We can own it any kind of way. All right. There's no survivorship, which means that if one, well, I ain't gonna use us, but if somebody that has a tenancy in common, one of them, say for instance, they move on. All right. Their interest passes on to the family. It don't go to the other shareholders. That's another key point with this, with tenancy in common. No survivorship and any shares possible is what they're going to test you on the test. Those two things right there, you got to know. All right. And obviously, you can't, they should be able to convey to outside parties. Now, here's what I would do if I had a tenancy in common, knowing that if one of the people die in the tenancy, that it could pass on to their heirs. I might do a first right of refusal to buy that interest. The other members in the structure, because I might not want to deal with my brother's kids, or I might not want to deal with my coworker's family, or a friend's family, or my friend's kids for that matter. So I'm gonna probably see if there's a way that I can set up that the other tenants can buy that interest. That's not gonna be on the test. That's just what I'm saying in terms of just describing more how that ownership could be. Or some of the things that could result from one of the tenants moving on, that interest does not transfer to the other tenants in that setup. It goes to their heirs. If they got kids, it'll go to their kids. If they got brothers and sisters and don't have kids, then it'll go to them. It'll go whoever's in succession, in the line of succession for that person. All right. Now, joint tenancy, this is the difference between this one and this one, is equal, undivided, joint owned. It's exactly opposite of this, right? When we go in, we have to have an equal share, 50-50, 25-25, 25-25, 33 and 33.3, whatever it's going to be, it's got to be equal. That's the difference. If you can pick up on that difference, then that's going to be the key. All right. That's the key to this right here. This is the next thing that's key to this: survivorship, meaning that the people that set up a joint tenancy with the right to survivorship, what they are doing is they're protecting whoever the other tenants are, and it's already figured out upon death. There's nothing that needs to do. If someone passes on in a joint tenancy with a right to survivorship, it automatically transfers to the other person. There's no probate situation that has to occur. There's nothing in terms of the courts have to figure out anything. It's already set up that way. And the people that would likely do that is husband and wife, or like a brother and sister, right? I want to make sure my brother got somewhere to live for the rest of his life. This might be a family heirloom, and we just keep passing it to the other tenants, or however we want to set that up. But the key to this, and what they're going to test you on the test, is if you know, and they're going to ask you the difference between joint tenancy with the rights to survivorship and tenancy in common. They're going to be like, which one is this? And the way you figure it out is joint tenancy with the right to survivorship. First, there's a survivorship key that it passes on to the other tenants in there, whereas in tenancy in common, it doesn't. And they're going to test you on if you can have equal or unequal shares in the joint tenancy. All right. So that right to survivorship is key. What they say is it may require express provision, saying that it's joint tenancy with the right to survivorship, but you wouldn't get into a joint tenancy unless it was going to be a right to survivorship, because and then the only reason you would get into a joint tenancy is so you can have equal shares, but you don't. I wouldn't. I don't understand why you would do that without the right to survivorship. So I always say joint tenancy with the right to survivorship. Now the four unities, all right, right here. What these are is time they have to get into the joint tenancy at the same time, on the same title, have the interest, the 50% interest, and then the possession, they have the right to possess it. So those are the four unities that make up a joint tenancy. Again, they have to enter into the agreement at the same time, meaning that if one of the joint tenants want to get out, say for instance you get a divorce, right? That person can't bring in another tenant into there because they didn't get into it at the same time as the first tenant. That's kind of confusing, but when this is set up, the people that are named in that structure of ownership have to all be there at the same time and enter into the agreement at the same time. You can't add somebody later, or you can't drop off and then somebody take, you can't do that. So, and then they all have to be, in terms of the title, they have to all have the ownership, the equal percentage of ownership. All right, and then interest is obviously their interest in the property. They would have interest in the property and would be able to, same thing that I was saying, they would have the right to use the property. They couldn't be excluded and in the possession. And I'll explain that deeper. You might get a question on that, maybe, maybe not, but I'll go over this a little bit more because I got a good video for this. Tenancy by the entireties is not recognized in Ohio. You probably won't see this on the test. It's likely that you won't see this on the test. It's like a 95% chance you won't see this on the test. It's not recognized in Ohio. We're a dower state. This is, but it's something that they test nationally because this is something that's recognized nationally. But this is something that a husband and wife will enter into. They will own equal undivided interest. Now applies to same-sex couples. So it's just like joint tenancy with the right to survivorship, but it's just well, it's not with the right to survivorship. This right here. So because there's no survivorship interest here, and then community property, joint property ownership by spouses as opposed to separate property. All right, so you won't get tested on that. You don't have to worry about. You don't really have to worry about the last two. If I was going crazy, I would just know tenancy in common, in and out, and this is easy to remember because we kind of figured that out. But these two, I'm not really going to commit a whole lot of time to studying those. Any questions on ownership? All right, we're gonna move to the next section. Joint tenancy in common. All right. Unity of ownership. Owners hold single title jointly. All right. That's the unity of ownership. All right. Equal ownership. Owners have always hold equal shares, 50-50. Transfer. May transfer to a new owner as a tenancy in common. I forgot to tell y'all that. If you do transfer it to a new owner, it converts into a tenancy in common out of the joint tenancy. That might be a question on a test, but that's something that you like. Okay, what the question would look like, it'd be something like if a husband, or it'll just be like if a joint tenancy in common, one of the tenants desires to be removed from the tenancy, what structure of ownership does the joint tenancy turn into? And it'd be tenancy in common. All right. And then with the interest remaining to the joint tenants. What that means is that interest that person is giving up, it turns into a tenancy in common, and that new tenant and the other person can figure that out, how they want to do it. Survivorship on death, interest and rights pass to the other joint tenant. That's what survivorship means. All right. I'm not going to go over community property. For the test, I would, if you get like the main stuff that I went over is really what I want you to really, really cover. But if you get a chance, start going over like trustor, trustee. Is very similar to what I described in a life estate. And then you got the beneficiary. So here's how it works. The trustor, let me use everybody in this group. All right, so Kiana, you buy a house, and you and Maria are like sisters and stuff. You buy a house, and you say, you know what, we're gonna keep this house in the family. We're gonna always make sure the women in our family own the house. I got somewhere to stay. And so you are the trustor. So you give the deed, or you give Maria the right to say, okay, Maria, you run this. Make sure the ladies have a place to live in a house. You might be in California. The house might be back here in Ohio. Maria's back here in Ohio, Kiana, you in California. You're Maria and Maria's sisters, and you say, hey, Maria, I want you to make sure the ladies of the family back in Ohio got somewhere to stay. I'm gonna trust you to, make sure that happens. So you name Maria as the trustee. Now, the other women in the family, it might be a big house and shaker or something. They always got somewhere to live. With the people that's living in the house, the women in the family are the beneficiaries, right? And that's very similar to a life estate, but it's just set up differently, right? Or sometimes what they'll do is they'll have a lawyer be like the trustor, right? And then the lawyer would be, I mean, the trustee. I own the property. I'm gonna turn it over to the lawyer to handle and manage for the beneficiaries. So if you can learn that, that's something that you'll need to know when you're just dealing with stuff in real estate. That's a higher level, more academic type of thing to know as a realtor. But it's a lot of money in like probate and stuff like that. Because, and this is not gonna be on the test or nothing, but one thing I noticed is, and I said this the other day in class, if you know how to identify people in duress or need to sell or it's just not going right and they own real estate and you can get it, you can provide them with an extremely good service to either sell their house as a realtor, or if you got it, you might have some investors that want to buy houses. It's just a good thing to know, because what that does is it always, those are the people that are getting ready to dispose of a house, someone that's in a divorce, someone that is going through a probate situation. They're going to do something with the house. It may even stay, it might stay in the family. So then if it stays in the family, that's no go. But that person might own multiple houses and their family might be out in California or out in the West Coast or somewhere like that. And they don't want to manage 13 houses or 12 houses back in Cleveland. So they just want to sell them. So what I'm saying is if you can learn probate and you can learn, how to search legal news for divorces and that type of stuff, there's all types of money in that. And you're doing that because these people are probably going to be trying to dispose of a house. So it's real good to know like probate. It's real good to know it's real good to know how to read that legal news and look for divorces and just people in duress. And it's not like you're taking advantage of them, but you have a service that you can offer them because you know what the situation calls for, and you're an expert at that. Um, so, but yeah, I don't think you're going to get tested on trust on a thing, but you might. But it's pretty similar to a life estate. So if you got the understanding of a life estate, you can kind of understand this here. The only thing different is that in a life estate, there's really not a trustee. The trustor directly gives it the interest to the beneficiary. But they may have somebody monitoring the life estate, like an attorney or somebody like that. But if you can remember that, that's great. And if you get a question on it and you get it right, that's even. If you get a question on it, it's going to be an easy question. It's probably just going to be like a definition question. There ain't going to be nothing real tricky. All right. The next thing is condominiums. Condominiums is a type of ownership, like you like, or it's a type of it's a property type. I'm sorry, it's not a type of ownership. It's a property type. Now, when you own a condominium, the ownership of a unit of airspace plus undivided interest in the common elements as a tenant in common with other owners. I don't really want to. I like the best way I think we can do and learn condominiums is by answering the questions and not necessarily going over them here, because I just want to show y'all what they're all going to be tested on the condominiums, and it's not that difficult. It could get real confusing because it's a bunch of people owning a share of a area, and they pay based on their share that they own. So if you can imagine a pie, we all own the pie. I got a bigger slice than Kiana, so I pay more towards the taking care and maintenance in that pie. It might be common areas that we all got to pay for. It's not confusing once you get to really understand it. It's very simple. But I want to kind of just show y'all what some of the questions they're going to ask on the test in regards to then just going over this. Let's cooperatives. So the way on cooperatives, because this is probably going to be one question on the test about it, and it's going to probably be like what's different between the cooperative and the condominium. But cooperatives are easier to for me to explain. So cooperatives are really present in like high dense places, like where the density and the population is great. So like in New York, you'll see co-ops. California, Los Angeles, you'll see co-ops. Chicago, you'll see co-ops. And what it is like the building is a piece of stock. It's like a stock, right? And you own a share in that stock. With owning the share, you get assigned a unit. All right. And it's a proprietary lease that is just on in proprietary it's in perpetuity, and it just goes on forever until you sell it your share in that building. Now when you own it, based on the shares that you own, is what you in terms of in terms of what you have to pay towards like maintenance and a reserve or just to take care of the building and stuff like that. So that's a little bit different. When you hear cooperatives, think of high dense places with a really huge population. New York, Chicago, maybe Boston, Houston. You might see some, and definitely gonna see some in Los Angeles. And they just own a share of a building, and that with that share you get assigned a unit, and you have with that lease is the unit. That lease is for that unit. All right, so that's what a co-op is. A timeshare is that you're pretty much buying time with other people that own a timeshare in that piece of property. With that timeshare comes a periodic use of that property, um, and you might get 2 weeks, you might get a month, but all of the people that own a timeshare in that property can use it. You're probably not going to see a question about timeshares. All right, so we had encumbrances and liens. So the next thing that I want to do is show y'all. This is probably important. You probably get like 3 questions on this. I want to show y'all this because this is a good way to explain it. The best way I didn't seen to explain it. Hopefully, I can find it real quick. And if y'all want me to share this with you, I will. I found it. All right. So know the definition of encumbrances, easements, restrictions, liens. Also know the difference between a financial and physical encumbrance. All right. Now, remember, we're talking about ownership now. This is a blank sheet of paper. This is how we want to hand and transfer properties with no encumbrances on it. So when you think of an encumbrance, think of like the tree trunk. Like when you see a tree, just think of the trunk. And then think of all these other things that are coming off of it as branches. Like once you got an encumbrance on the property, that's a cloud on the property. Now there's a bunch of different ways the clouds are that come. Some of them are financial clouds, like a mortgage lien. It could be a property tax lien. Um, like everybody has a tax lien. Everybody has a lien put on their property once every year, and that's the tax lien. And it's put on the property at the beginning of every year, the first day of January or whatever year it is. Everybody has every taxable parcel in the municipality in which you live in Ohio at least, has a tax lien put on their property on the first day, January 1st or whatever year it is. The way you get rid of that lien is you pay it, but it's a financial lien that's put on the property. All right. Another type of financial lien that's put on the property is like an association do, like an HOA, like you got to pay this. All right. Those are financial liens. Physical encumbrances or financial encumbrances. Physical income. So what am I saying? Liens are an encumbrance. All right. So that's the type of encumbrance that you need. That's a branch off the tree. So all liens are encumbrances, not all encumbrances are liens. Another type of encumbrance is a physical encumbrance. And I'm gonna just show you right here. Mortgage, HOA lien. A physical encumbrance is like an easement, right? Because someone else has the right to use the property and you don't have full use of it, and they have the right to use that piece of property through an easement. Now, everybody probably that's connected to utilities has an easement on their property. It's a utility easement. Every property. If you're connected to water, if you're connected to electricity, if you're connected to cable and like all that stuff, those types of utility companies have an easement on your property. Like I said, if a tree falls on a utility line and an electric line comes down in your backyard, they're not calling you at work talking about we need to go in your backyard. They're going in your backyard and they can do that through the easement that they have on a property. Or if they need to service the light, the pole, they have the right to access your property without your permission because through that easement. Um, so that's an easement. Another way that you could use an easement is the right to have somebody use a piece of your property. The example I use for that is like in Shaker or Cleveland Heights, some of the older communities, you'll see a house right here and a house right here, and they both use the same driveway. One of those houses have an easement, all right, and it's probably what they call an easement appurtenant, means that it stays with the property, it transfers with the property, it does not leave the property. All right. So that's another type of easement. But know what an easement is. An easement is an encumbrance, and all easements are encumbrances, but not all encumbrances are easements. All liens are encumbrances because encumbrances are the tree trunk. So when you hear the word encumbrance, just think cloud. Something's wrong with the title. All right. An encroachment is like like I use the example of somebody constructing a fence, they didn't get a survey, their fence is almost 2 feet onto your property line. You go to sell the property, the surveyor surveys your land and notices that the fence encroaches on the property. Until that thing is remedied, that person there's another person's property on the property and it's encroaching. So an encroachment is a cloud on the title. All right, because it limits the use or restricts the use, or it's just an illegal use. All right. And that's the best way I can explain it. Know the definitions of liens, know the definitions of easements, encroachments, and know what the encumbrance is. And that's pretty much that's the start of it. All right. Going back to here, encumbrances are non-possessory interests limiting legal ownership. They limit ownership. That's what an encumbrance does. So when you go to sell a property, you always want your buyer and you want your seller to give somebody a blank sheet of paper and receive something. Because if something's on this paper, it's limiting my ownership, right? It's a cloud. Um, okay, so I'm not gonna go on this because none of this stuff you're gonna get tested on, but it says encumbrances that affect the use. So what that means is like an encumbrance that, like, if somebody encroached on your property and you're not able to use the whole property, like you might want to build a garage, but it's a fence there now. So it affects the use. And then there's encumbrances that affect the ownership value in the transfer. Like you can't transfer it or it's impacting the value of the property. But none of this stuff is going to be on the test. I would just know the definitions of easements. And there's a certain couple types of easements you need to understand. An easement appurtenant, that's a definition that you need to understand. They will test you on that. And pretty much it means it runs with the land or a transfer with the land. It attaches to the estate. All right. We're going to talk about dominant and servient tenants. We're going to need to know the definitions on those two as well. We're going to learn this through answering the questions. Some of this stuff we're going to have to because it's just so much. And I'll tell y'all when you need to know the definitions. But all this stuff under easements, I would know. Eastman and Gross is the one with the utility company that I was telling you about. The difference between the Eastman and Gross and a pertinent easement is it does not attach. The gross one does not attach to the land. So when the property transfer, the gross don't necessarily easement does not attach to the land. It doesn't transfer with the land. All right. You might get a question about prescriptive easement. This is what we call adverse possession. which means that that person they used the property illegally with or without permission, and they owned it or and took care of it, and you are not owned it, but used it and took care of it for a period of 21 years in Ohio. And then a license is different from an easement. A license is just granting the right to use the property. It does not attach to the land, is not transferable. The key important thing about a license, you can revoke a license. Like if somebody getting on your nerves and you letting them use your property, you give them a license, not an easement. If they getting on your nerves, you can just say, hey, it's over with. All right. And it ceases on the death of the owner. So if the owner dies, that license ends. Encroachments, know the definition of encroachments is an unauthorized intrusion of one owner's property onto another's. May require a survey to detect. I said that. May become prescriptive easements if not remedied over prescriptive period. In other words, an encroachment, that's how you get somebody's property. You encroach upon it, unauthorized, you take care of it for a long time, you're using it for a long time. And so after, excuse me, after that time passes, you have the right to use it. You have the right to own it. You can we'll go to the courts and request a prescriptive assignment of the ownership interest in that. So just know the definition of what an encroachment is. More importantly, knowing an encroachment is a type of encumbrance. A deed restriction. Remember when we were talking about fee simple absolute and fee simple defeasible? Those conditions in the defeasible are deed restrictions. Conditions that are put into the deed to say, I don't want you to do, or I want you to do something with the property. All right. Or you have to do something with the property. Somebody might sell you a piece of land and say, hey, you got to keep it and you have to harvest vegetables or on this property. That means that you have to do that. It could transfer to the other person if that's not abided by. So it's to do something or not to do something. Typically a deed restriction is going to go with the property upon transfer. So even if you sell it to me with the restrictions, if I sell it to somebody, those restrictions also follow. Sometimes the municipality can put restrictions on them, like setbacks, land use, and these, but you won't be like setbacks is like how far the house has to be set back from the street, how you can use the land and stuff like that. But that's not something that you're going to be tested on. Deed conditions, you won't be tested on that. Deed covenants, you won't see anything like that. Let's look at liens right here. A lien it could be a financial lien. It's just a claim attached to the real property and personal property as secured for debt. It could be a mortgage lien. It could be a tax lien. It's recorded on the title, effectively reducing the equity and the amount of the lien. So in other words, what that means is if you own a house and the house is worth $100,000 and you got $100,000 worth of equity, whatever the value of that lien that's on attached to the house. So say for instance, there's a $20,000 lien. That lien is worth $20,000. That reduces your equity to $80,000 or the amount of the lien of that lien. I'm not gonna go over that. That's not something that we're gonna be testing on. A lien attaches to the property. Property can be encumbered by multiple liens, meaning that you can have a lien for a mortgage, you can have a mechanic's lien, you can have a tax lien. It could be a bunch of liens on the property. Liens terminate upon payment and recording satisfaction. What that means is once you pay it, you want that person who you paid to record that you paid them at the county. All right. The types of liens is really what you're going to get tested on. You need to know what the difference is between a voluntary lien and an involuntary lien. And voluntary lien is a mortgage, meaning that you mortgage your property. Like here's the mortgage, give me the money. Use this mortgage as collateral. That's voluntary. You did that. All right. You probably had to go to a bank and you filled out an application. You did that. A tax lien is going to go on your property no matter what. So that's an involuntary type of lien. You don't have any choice. You got to pay your taxes. Every year, it just got done collecting taxes on February. So they put the lien on the property in January 1st of 2025. And you had till February 20th, I believe, to pay that lien. You can pay it in full, you can pay it in halves. right? And then they build you for it. Once you pay it, that you don't have the tax lien anymore, and it's over with for that year. And so that's not voluntary. That's involuntary. I don't think you really need to know the difference between a general and specific lien, but a general lien is against anything that you own. A specific lien is like one that's specifically attached to your house or a car or something like that. And superior and junior, that's something that you're going to want to know in real estate, but you're not going to be tested on that. But pretty much in Ohio, they have what we call recordation. And hold on one second. Crazy. Okay. All right. So yeah, you go get tested on the voluntary, involuntary, general, or specific. It may be some questions. We're gonna see some questions about this stuff. So when we talk about it, we'll just go back and refresh ourselves. But I'm just kind of covering. There's a lot of stuff in here, but you're only gonna get like 8 questions out of all this stuff. But like if I was to know stuff, I would know my definitions of the encroachments. I would know what an impertinent easement is. I would definitely know what an encumbrance is and how it affects the title. Um, a lot of this, so all of this up here, all this joint tenancy stuff, all of this, I would know all of that because we ain't even done with property ownership because we haven't even talked about legal descriptions. All right, so they talk a little bit about foreclosure, but we're not really going. There's not a whole lot of questions on foreclosure. Um, Lien priority, they'll ask you if you know what lien priority means. Like real estate tax liens have priority over everything. Period. All right, real estate tax liens. Then you got special assessment liens. Then you got federal real estate tax or federal estate tax liens. And so there's a hierarchy, but all you really need to remember is that real estate tax liens, it has the highest priority over anything. Like they gonna foreclose on you if you ain't paying your property taxes. And you typically, I don't know, it depends. It could be 3 years, it could be 4 years, it could be sometimes it could be even longer than that. But at some point, they are not going to allow delinquent taxes to be present in the treasury of the county, or whatever county you're in, will file a foreclosure with the prosecutor's office if you don't pay them. And so you just need to remember that that supersedes your mortgage liens, mechanics lien, anything. If you get if a real estate tax lien get on your property, that's gonna have the highest priority, and that's all you really need to remember for the test. When they ask that, they'll say a bunch of stuff. If it's a property tax lien, that's the answer. Period. All right, foreclosure. There's not really a whole lot in a foreclosure that you need to know. But this next thing is real important. Right here, lien versus title theory state. What it means is in some states, like Ohio, when you mortgage the property still stay in your name, and you give them a mortgage, right? In some states, though, it doesn't transfer in a person's name. Okay, so the lien theory state the lender of the mortgage property holds equitable title. So that's the lien theory state. That means the lender of the mortgage property holds equitable title rather than the title rather than legal title. Borrower holds legal title. They have legal title. Legally, they're the owner, but it stays in this the lender's name, or they might put it in a trust or something like that. Here, as in the title theory state, that's one where we use mortgages, um, where that's where the lien holder holds legal title. The lender holds legal title to the mortgage property until the mortgagor satisfies the terms and obligation of the loan. And so what I did is I had those backwards, y'all. So this is where the lender holds the legal title of the mortgage, the title theory state. This is Ohio lien theory state. The mortgage property, the lender of the mortgage property holds equitable title. So they hold the equitable title while the borrower holds legal title. That's my bad. So title theory states is like maybe I think Texas is a title theory state where it's like a trust or something like that that holds title into the property until the person who pays or who has the loan pays it off. You probably won't see that on the test. Likely you won't, but if you do, I will talk about it more once we come up if there's a question about that. So it's 8 o'clock. Um, it's a lot here. It's a lot. What I would just say, and what I did for y'all is I started to put some of this stuff down on here. And we just added it to that sheet that we've been doing the study guides for. Like I I wouldn't go take the test. Honestly, I know it's a lot of stuff, but I wouldn't go take the test until I had a good understanding of all this stuff. Now we at what's this? It's like one. And then some of the stuff once you get it, it's just in you, you know. So you ain't really once you get it, it's there. Um, and so yeah, it's starting to get a little lengthy, and it's a bunch of more stuff that I got to put on here, but I'll share it once I put it on there because we still got a couple more days of property ownership. Um, Here, let's do this real quick. Ask her a couple of questions and then we'll get up out of here. It's 8:05. The more participation we get, the faster we can get up out of here. Now we're not going to answer any questions about metes and bounds and legal description. I'm gonna cover that in the next class, in the next session. So if we get a question about that, we're gonna skip it. All right, here we go. And what I'm going to do is I'm going to point out what they're trying to ask y'all in these questions. We're going to do a little bit of that. A buyer is interested in a property where ownership is shared, but each owner has a specific undivided interest in the property. What type of ownership is this? Let's unpack that again. A buyer is interested in a property where the ownership is shared, but each owner has a specific undivided interest in the property. What type of ownership is that? This is what they're now, the way they're asking us, and look at the answers. Joint tenancy, tenancy in common, community property, sole ownership. They're testing you if you know the difference between joint tenancy and tenancy in common. There's one key word in this question that makes me know what the answer is. Anybody can identify that one word? Because if you can, that's the key to the question. Hmm. There's one key word, and they didn't say it the same way that I just went over it, but it means that. That's how I'm interpreting it. I give y'all a couple more seconds and then I just get to it. And these are the keys that we got to pick up on these types of questions because this is just a definition question, but it's one word in there to me that gives me the answer. Because here's the thing, let's unpack this. Does joint tenancy have undivided interest in the property? All the tenancies have undivided interest. You cannot restrict somebody in using a property to them having interest in that property because they own a share or they're a tenant. So both joint tenancy and tenancy in common has that.
So it's Tennessee and common.
So, so look, both of these have undivided interest. So this means nothing to me because I know both of these do. Now watch this. The reason why I say that is this here. Let's go back there with the tenancy in common, right? So what they say with tenancy in common, equal undivided interest. T joint tenancy, tenancy in common, undivided interest. Tennessee by the tire. All of them have undivided interest, so that means nothing to me. That part means nothing, right? So when I go back to the question, the key to this question to me is specific, because that means that, remember, in tenancy in common, we can all own different types of ownership. At least this is how I'm interpreting it. That's how I'm looking at it. Specific means you got 50, I got 50. That's specific. It ain't all over the place. So if that's the case, I think this is joint tenancy, not tenancy in common. Because both of them setups, the ownership is shared. It could be through two people. It could be through, it could be, that's all common. But this is what they're testing you on, this part of the sentence right here. So anybody want to pick the answer? Y'all can disagree with me. I don't know the answer. I like these are new questions. I just got this one. I do not know the answers to these, but I'm picking joint tenancy because of this word right here. Anybody disagree? Watch it be wrong, y'all. Look, all that stuff I said. See? Now, but see, here's the thing. Let's see why. Because it's about this right here. All right, let's see here. Tenancy in common is the correct form of ownership described in a scenario where each owner possesses a specific undivided interest in the property. This means that each tenant in common holds a fraction interest in the entire property, which can be equally which can be unequal size of unequal size and has the right to use the property and enjoy the entire property. One of the key features of tenancy in common is that upon death, one of the tenants, their interest in the property passes to the heirs or as directed by the will, rather than to the other tenants, which is the principle known of right to survivorship. So when I saw specific, I don't look at it the same way. Specific, they said specific possesses a specific. I mean, joint tenants possesses specific. So it comes down to just getting that right that way. So that's my bad on that one. But like I said, I don't know the answers to these questions. I'm just breaking them down with y'all. Here's a meets and bounds question. We won't answer this one because we're gonna go over that next class. It says when a property with a mortgage lien, when we start hearing those words, we want to think of that's an encumbrance and it's a financial encumbrance. Mortgage lien. A lien is an encumbrance and it's a financial encumbrance. All right. When a property with a mortgage lien, a mechanics lien, and a tax lien is sold, which lien is typically paid first from the sales proceeds? I told y'all, we just got through talking about that. Is it tax lien, mortgage lien, mechanics lien equally divided amongst liens? We can just answer this one because I want y'all. This is an
X.
it's tax lien, right? All
Yep.
right. Yeah. So we're gonna read that. The tax lien holds the highest priority amongst the liens listed, meaning it is typically paid first from the sales of the proceeds of a property. So what they're saying is, say for instance, a property was foreclosed on, and at the sale, the property sold for $100,000, but the property had $120,000 in liens on it. The tax lien, whatever it is going to get paid first. And if there's money left over to pay the other liens, they get paid. If they don't, they just lose out. So that's what that means in terms of the priority. Tax liens hold the highest priority among the liens listed, meaning that it is typically paid first from the sales proceed of the property. This precedence is based on the principle that debts owed to the government take precedent over debts owed to private parties. Tax liens arise from unpaid property taxes or other taxes owed by property owners. Given their nature, governments prioritize these liens to ensure that essential public services funded by those tax dollars are not disrupted. Therefore, when multiple tax liens are sold, the proceeds go towards satisfying any outstanding tax liens before addressing other debts. Now, remember, we're selling property rights, and we know liens impact the ownership. So when y'all out there practicing, one of the most important things you got to make sure is if these properties don't have back taxes or unpaid taxes, because the government, like, they coming for it. And I mean, I'm not saying it to scare anybody, but it's a share sale every Monday and Wednesday. So every day, I mean every week, it's a share sale every Monday and Wednesday. So that's what I mean by that. That's serious business right there. But like I said, if you know how to um understand foreclosures, probate, all that stuff, you can, and you know how to get properties and find properties, you will always have somewhere in real estate. All right, the next question. All right, this is about easements, it looks like. A homeowner wants to sell a property that has an easement and gross granted by a local utility company for maintenance of power lines. Now remember, an easement and gross is associated with utility companies. So when you hear easement and gross, think of utility companies. All right. It says a homeowner wants to sell a property that has an easement and gross granted to a local utility company for maintenance of power lines. How should the real estate broker advise the client regarding the easement during the sales process? So painting the scenario, you got a property that you're going to see with a buyer. You get to the property and or no, you're there with the seller. It says the seller. Um, and you're talking to the seller, and the seller says, "Hey, um, we have an easement and gross with the utility company to maintenance the power lines in the back." So they're saying, as the listing agent, what advice should you give to the owner? All right, it says, how should the real estate broker advise the client regarding the easement during the sales proceed? So here's the answers. Recommend terminating the easement, number one. Number two, disclose the easement to potential buyers. Number three, increase the asking price. Number four, easement terminates upon sale. So most of the time, if you see anything about disclose in the answer, that's probably the answer. I'm gonna just keep it 100 with you. Obviously, that's gonna be the best answer on here. Does anybody disagree with disclose the easement to potential buyers on this one?
No.
That's what y'all would do. All right. And that's 98%. So that's why I did that. Because if that one's like, everybody should know if you got an easement, let's disclose it. All right. I don't know what the action is math and property ownership. We're gonna skip this one. All right, here's another question. Which about joint tenancy, which feature is unique to joint tenancy? Unique to joint tenancy. Now we're gonna go this, we're gonna cheat. We're gonna cheat and look like this. We're gonna go over there and look because we're trying to retain it. All right, here's joint tenancy right here. Equal undivided interest jointly owned. Equal undivided interest. Survivorship may require express provision, but the right of survivorship. And then the four unities, but that's not probably going to be part of the question. So we need to pay attention to these two things right here. Equal undivided interest means you got to own 50%, I got to own 50%, and it has the right to survivorship. All right. All right. Which feature is unique to joint tenancy? Equal ownership shares. Now, what we got to ask ourselves is that present in the other forms of ownership? Is equal ownership shares is that a feature of tenancy in common? Think about it. Right of survivorship. Divisible interest. No individual control. So I'm gonna get rid of one, and y'all get rid of one.
No individual control.
I agree. So now it gets down to this: which feature is unique to joint tenancy? Is it equal shares, equal ownership shares, or right of survivorship? Unique to joint tenancy. This is a good question. It's a tricky question, though.
I'm thinking the first one.
That's right. That's
Okay.
right. That's right. I don't like it though, but equal ownership shares is unique to. I don't know though, man. see, we gonna see, but I mean, we like I could. Let's pick an equal ownership shares. Let's not go against ourselves. Forget it, man. And we was wrong on that. All right, so right to survive, because see, you can have joint tenancy without the right to survivorship. So that's where I went with it, but it is what it is. Let's read why though. All right. It says joint tenancy is a form of property ownership where two or more individuals hold title to real estate jointly with equal rights to the whole property. This type of ownership is characterized by four unities: unity of possession, interest, time, and title. Amongst these distinctive feature that sets amongst these a distinctive feature sets joint tenancy apart from other forms of co-ownership is the right of survivorship. This means that upon death of one joint tenant, their interest in the property automatically passes to the surviving joint tenancy rather than being part of the deceased estate. Now, joint tenancy is separate, and joint tenancy with the right to survivorship is a different thing. That's why I really didn't like the question, but it is what it is. It said the right to survivorship is what makes joint tenancy unique. In the event of joint tenant's death, their share of property, their share of the property does not go to probate or become part of their estate to be distributed according to their will or a state law. Instead, it immediately transfers to the surviving tenants, ensuring a smooth transition of property ownership. This feature is particularly appealing for individuals who want to ensure that their share of the property ownership passes to the co-owner without complications of probate proceedings. So yeah, that's a good. But we are going to start picking up unique to joint tenancy. We just got to remember it's right to survivorship. I kind of disagree with the way they said it because joint tenancy is different. It takes a special provision. It is what it is. We're gonna keep it moving. All right. All right, here's one that we should be able to figure out. Which of the following best exemplifies ownership and severalty? Is it a married couple holding title to their home as joint tenants? An individual who purchases a home and holds the title in their name alone? Two business partners owning an office building as tenants in common? A group of investors sharing ownership interest of property with the right to survivorship? I'm going to read those again. Which of the following best exemplifies ownership and severalty? Severalty. A married couple holding title to their home as joint tenants. An individual purchasing a home and holds the title in their name alone. Two business partners owning an office building as tenants in common. A group of investors sharing ownership of property with the right of survivorship. I'm going to get rid of that one. What y'all think in terms of eliminating one?
So you said severalty is, it sounds like a lot of people, but it's really only one.
There you go. There you go. So
I
which
think
one of them is that?
an individual
There you
who
go.
purchases a home.
That's the key right there. All right. An individual, first off, let's figure out why they call it severalty. I think they might say it in here. Ownership and severalty occurs when a property is owned by one person or entity exclusively, granting them the full control over the property. This concept is fundamental in real estate as it determines the rights and responsibilities of the owner, as well as how the property can be transferred, encumbered, or utilized. It contrasts with other forms of co-ownership where the property is held by two or more parties, each with specific rights and potential shares and responsibilities. An individual who purchases a home and holds the title in their name alone exemplifies ownership and severalty. This situation means that the individual has exclusive rights to the property, including the right to use, sell, or lease the property at their discretion. There are no other parties with legal claim or interest in the property, which simplifies decision regarding the property. This form of ownership is straightforward and offers the owner complete autonomy over their asset, making it a clear representation of ownership and severalty. All right. They didn't talk about severalty, but we're gonna find out what severalty, exactly why they call it that. All right. An investor is looking to form a business entity to purchase and manage a portfolio of rental properties while limiting personal liability. Which business structure best serves this purpose? So, is it sole proprietorship? We should be able to figure this one out. Is it sole proprietorship, general partnership, corporation, or limited liability company? I'm going to get rid of sole proprietorship. They take on all the liability. We can get rid of one. We're gonna go to 8:30, y'all. Answer a couple more questions. We got about 6 more minutes. We'll go to 8:30 for this one and on this one, and because this is some stuff. Just study these definitions, and we're gonna keep grinding it out. We'll do a Saturday class too. I'll send out a text and if y'all want to get together on Saturday, we can. But let's finish up a couple more questions and get on up out of here.
Can we get rid of maybe corporation?
Yeah, I like that. All right. The question says, an investor is looking to form a business entity or purchase and manage a portfolio of rental properties while limiting personal liability. Which business structure would best serve this purpose? Is it general partnership or limited liability corporation?
Oh,
You say what? I didn't hear you.
I didn't give an answer, but
Oh, okay. My bad.
thinking I was flipping paper.
Okay.
I was trying to look on my cheat sheet, but so LLC,
That's cool.
General LLC.
All right. I agree. All
Okay.
right. An LLC, a limited liability company, is the correct entity for an investor aiming to purchase and manage a portfolio of rental properties with a structure that limits personal liability. An LLC combines the limited or liability protection of a corporation with tax efficiencies and operating flexibility of a partnership. This means that the person, assets of the members, owners of the LLC are protected from the company's debts and liabilities. In the context of real estate, this is particularly advantageous as it shields investors from personal liabilities in most cases related to the property, such as accidents or lawsuits. Furthermore, the LLC for profit allows for profit and losses to be passed through the members without being subject to corporate taxes, providing a tax-efficient structure for real estate investments. We're going to answer two more and get up out of here. All right. Well, do that one. Yeah, I don't feel like even tackling now. Okay, here go one about tenancy in common. In tenancy in common, what right does an individual owner have? Right to survivorship, right to sell without consent, right to exclusive possession, right to convert to joint tenancy. I'm gonna get rid of that one. This is a really good question though.
Get rid of 3.
Cool. So that leaves in tenancy in common, what does the individual owner have? Right to survivorship, right to sell without consent. Tenancy in common.
Um,
I'm gonna go with B or 2 because I think it says no survivorship on tenancy in common.
Right. And do you agree with that, Kiana?
yes, I do.
Right to sell without consent. Either it's going to have some right to survivorship. Well, right to survivorship and right to sell without consent is kind of different. But right to survivorship is if somebody passes. Right to sell without consent is just saying, hey, I want up out of this tenancy in common. I don't have to get anybody's permission. All right. So it says right to sell without consent is fundamental characteristic of tenancy in common that distinguishes from the other forms of property co-ownership. Each tenant and tenancy in common holds an individual interest in the property, which means they can sell, lease, or mortgage their share of the property without needing permission of the other owners. This level of autonomy allows greater flexibility in managing one's investment or interest in the property. However, it is important to note that while our owner can sell their interest, the new owner will enter into the tenancy in common under the same conditions as the previous owner. All right, next question is the last question. Let's knock it out. It is a question that we can answer. It says, which of the following best describes the form of property ownership where the owner has complete control and rights over the property? Which of the following best describes the form of property ownership? Remember, what's property ownership? Think about those things I told y'all that was property ownership, where the owner has to complete control and rights over the property. Is that a leasehold estate? Is it joint tenancy? Is it fee simple absolute? Is it tenancy in common? You see how they mixing these things up, like the leasehold estates, the free and leasehold estate stuff. They're mixing all this stuff up on y'all. But let's read the question again. Which of the following best describes the form of ownership where the owner has complete control and rights over the property? Is it leasehold estate, joint tenancy, fee simple absolute, tenancy in common? I'm gonna get rid of leasehold estate.
You can get rid of tenancy in common.
All right. So that leaves joint tenancy and fee simple absolute, and it says, which of the following best describes a form of property ownership where the owner has complete control and rights over the property? Which one is it?
3.
Right. Now, let me tell y'all on the test real quick. I knew kind of instantly when I read the question, I knew it. When I feel like that, I'm going to slow down because that means that's 1 in 56. And I'm going to make sure it's saying what I think it say. Like, read this boy about 3 times. Which of the following best describes the form of property ownership where the owner has complete control? Like, I know exactly what that is. Let me just make sure they ain't trying to trick me. And you look at the answers, you read it again. Because this is 1 in 56. I felt everybody knew that. Like, I knew y'all knew that. So we're gonna pick this back up. Like I said, we're gonna do a Saturday class. And I'll text it out probably about 11 o'clock. And I'll text out the link if there's anybody interested.
Okay.
All
All
right.
right, ladies. I'll see y'all.
Thank
Okay.
you.